The timing of the lien is whether or not this is the timing of the lien. This was about 30 days too late to file the liens. It's missing their information. Their mailing address is missing from the lien. The statute makes that fatally defective. And the third, just like with the lis pendens, they didn't bother to mail it. We supplemented the motions a few weeks after we filed it because we realized that the liens had never been mailed, much like the lis pendens, Your Honor. So I'll kind of break the arguments down. To perfect a lien on a home, on a residence in Texas, it's the 15th day following the 3rd month in which the work was completed. There's no dispute that the work was completed or abandoned in October of 2022. The 15th day of the 3rd month puts a lien filing deadline of January 15th, period. They filed these on February 15th. They missed it by a month. It is too late, is invalid as a matter of law. In their response, they said, well, hold up. This is not a residence. This was a commercial project because it was owned by a house flipper. That's not what the statute says. And if I may I share my screen with Your Honor?
Yeah, let me enable that, please. There you go.
This is I hope Your Honor can see this. This is the definition that we're dealing with. This is in Chapter 53, Texas Property Code. A residence is the real property and improvements for a single family house, duplex, triplex, or quadruplex. And that's the part of the statute where we stop. There's no question that these are single family homes. It qualifies a residence. What the lien claimant has done is they said, well, keep reading, and then we're going to get to these qualifiers, capital A and capital B. And that's why I've highlighted the word or. There are 2 ors in the definition, okay? And you get to this second part, which deals with a multi-unit structure. So think condominium, think apartment building. The statute puts those in a different category, okay? So in their response, they said, well, hey, we haven't met these capital A and capital B because it's not owned by an adult person and it was not used or intended to be used as a dwelling by the owners. Those qualifiers, the capital A and capital B on the screen, only count if we're talking about a multi-unit condominium, apartment building, that type of structure. They're simply misinterpreting the statute. I wanted the court to see text, see that we have the word or appearing in there twice. Notably, there's no case law that they've attached that talks about this. A house is a residence. It's very plain and simple. In fact, if you get to further sections in the property code under the same chapter dealing with mechanics liens, it makes a distinction between residential property and homestead property. So statute certainly contemplated that you could have a residential project where the owner did not live or intend to live on the property. That would be a homestead. So what this is really saying is you can affix a mechanics lien on a residence under the 3-month regime, not the 4-month regime if you're looking at a commercial project, if capital A and capital B are met in an apartment or condo situation. So that's not what this is, Your Honor. If we look at the next fatal reason is under 53.054A7. That is that the claimant's information is missing from the lien affidavit. It appears nowhere. It doesn't appear in the text. It doesn't appear on the receipt. And it doesn't appear on the invoices, which is quite telling since the invoices attached to the petition do have an address on there. In their response, they cite this court to the Richardson v. Mid-Cities drywall case, and they write in their response that the holding of that case is that, well, it doesn't have to be in there. It's still substantial compliance, okay? That is not what that case says at all. That case actually, that lien, the address appeared in 3 places. It was on the affidavit. It was just past the jurat. It was on the return address for filing, and it was on the clerk's receipt. So in the Richardson v. Mid-Cities drywall case, it said, it did an analysis and said, did this provide a means of contact with the claimant? And because the address appeared in 3 places, it said, yes, that's substantial compliance. We don't have that at all here. And of course, the lien claimant is going to say, well, Chase, you know how to get a hold of me, but that's not the inquiry. The inquiry is whether the world can find the claimant. If my client sells this property, if a title company is running a title search, it should be able to get in contact with the claimant, obtain a release of the lien, and that's why the statute requires that it be in there. Okay, so again, if that address is missing, it can't substantially comply. It's just absolutely fatal. The last one is back to old habits with the lis pendens, a mailing. After a couple of weeks, after my client knew about the lien notices, I followed up and said, did you get a copy in the mail? You're supposed to get it mailed under 53055 of the property code within 5 days. Of course, my client had not. So we supplemented our motion and added that as a reason as well. In their response, if I may share my screen again, Your Honor. Okay, this is what they've attached in their response, saying, well, hey, we mailed it. What's
We can't
notable,
see what you're talking about.
sorry, Your Honor, let me,
You might want to, I think it wasn't open when you shared screen.
how about now?
The certified mail receipt.
Yes, Your Honor.
Okay.
So this is in their response. It's an exhibit, and they said, oh, look, we mailed it. What's notable about this, Your Honor, February 20th, that is the last date. That's 5 days after the hearing. I'm sorry, after the liens were filed. That's the absolute last day it could have been mailed. That's not a postmark. That's the same stamp that I have in my office in our copy room. So I've typed in the USPS tracking website, that same number, and lo and behold, the first day that the post office has it is February 21st, which is the 6th day. Statute is very clear. If it's not mailed within 5 days, it is invalid. The court must strike the lien, remove the lien from the property records. It does say that it was mailed on the 21st and that it's making its way through the USPS network. I don't doubt that there are issues with the mail, but what I do take exception to is an apparent mailing that occurred on February 21st at 9:49 p.m. That's the first record that the post office has of it, has of this mailing. Simply is insufficient evidence that it was mailed within 5 days. So any one of these three reasons, the late timing, missing information, or the late mailing, 53-160 of the property code is very clear. The court must enter an order removing those liens. It's not a commercial project. It's for a residence, meets the definition of a residence. And I think that it's pretty clear that the court should enter an order removing these liens. Thank you.
Response?
Yes, Your Honor. Well, first to start, the statute that defendants have brought this motion to remove liens under, it does state that the claimant is allowed 30 days notice before a hearing. And I will say that an amended motion was filed and it cut into the 30 days, so it hasn't been 30 days since that amended notice. And so I would argue that first, there isn't proper 30-day notice to actually have this hearing today.
Well, let's deal with that first, Mr. Garrett.
We added the signature page for Mr. Pham's affidavit. There was no substantive change to the motion. They filed a response and said, hey, Mr. Pham's affidavit wasn't signed. My assistant simply uploaded the draft version and not the executed version. So that was the only change, was literally to put his signature in the motion. I don't think that that resets the clock on notice. All of the arguments are the same.
Did you, I'm not familiar enough with the statute. Did you move for leave or to do that, or is that required?
It's not required, like in a summary judgment sense, where the evidence has to be on file. It just says simply 30 days notice of the hearing. So based on the paucity of language in the actual statute, I don't think it renders it defective, and I don't have any concern that this gets. I think at worst, if this went up to the appellate court would say, okay, well, his affidavit wasn't on file for 30 days. That still doesn't cure the timing. It still doesn't cure the mailing. It still doesn't cure the content of the affidavit, the lien affidavit itself that fails to have the claimant's address. So again, that was just a filing error. They said, hey, it wasn't verified. We said, yep, you're right, it wasn't. If we need to reset this hearing so that the court's comfortable, I'm more than happy to renotice it at a later time. I don't think it's necessary.
Response?
Right, I will say there is no case law regarding it, but the statute does say that it's 30 days is required. 30 days notice is required prior to actually having a hearing. So, I mean, there's no.
I guess my thought on this is that, you're making, Mr. Garrett, part of this is, the 5 days versus 6 days. You're making a pretty technical, strict interpretation of the deadlines here. And so kind of what's good for the goose is good for the gander. I feel like if you want me to consider the affidavit, then you would need to give 30 days notice, unless there's case law to the contrary. So if you don't need me to consider the affidavit and you can go forward, you want to go forward without it, I'm happy to do that. But I do feel like this is all about deadlines and strict interpretation. It needs to go both ways.
I will say that affidavit is required for the motion. So, I mean, it couldn't be granted anyway if they had a valid argument.
Mr. Garrett, you're muted.
I'm so sorry, Your Honor. This is the first I'm hearing of the complaint about the timing was not in the response, but I would be happy to reset it and take that away. I apologize.
And we just swapped out.
Your sound went out again, Mr. Garrett.
What happened?
Okay, you're back.
All
right, so let's go ahead and reset this. And have you guys been to mediation on this, or?
No, we have not.
Why don't you guys try to go to mediation? I mean, is there grounds for a mediation? I mean, is there some way to reach common ground on this thing or not, do you think? Would it be a good idea to do mediation now?
I mean, I think the parties could benefit from mediation just to, to discuss the amount of invoices that, if we can come to some kind of agreement regarding the invoices, so I believe that they have an issue that's being asserted, so.
What do you think, Mr. Garrett?
I'm never opposed to mediation. I would just look at the timing, and we have a lien on a property or 2 properties that have been sold. My client is probably about to catch some litigation because of that, which might just make this case bigger. So I do think we need to get the liens dealt with so that my client understands what exposure it may have to the person.
Do you want me to, I could call like burden mediation, see if we can get you guys fit in pretty quickly there, or what do y'all think?
Sure. I expect we should be able to accomplish a mediation within 30 days. I think we could probably do that. It just depends on what everyone's schedule looks like.
I agree.
Who do you want to use? I don't know who I appointed, but who do you want to use?
A good person for this, he's retired, but he does Zoom mediations, is Robert Shapiro. Does your Honor remember him? He's retired construction lawyer. He was one of the authors of the construction law manual. I've mediated probably a dozen cases with him in my career. He's very good. He pushes hard. Since he's retired, I think he's got pretty good availability.
So I'd say, I don't know Shapiro, but Shapiro sounds fine, or King Pfeiffer. Judge Pfeiffer was kind of an expert in construction law.
It's a good name.
Another guy who's pretty good at this stuff is Mike Metcalf. He's semi-retired. But any of those are fine with me. I'll just kind of let you choose, Ms. Ibe.
Okay. I think we can sort. I'm open to all 3 names. Judge Pfeiffer, Metcalf, or Shapiro. I'm open to all 3.
What do you think?
I'm open to either of the 3 as well.
I think out of those 3, Shapiro would probably be our best bet for open-ended availability.
Okay. All right. Rhonda, let's go ahead and get Rhonda, go ahead and put a mediation order on this. They need to mediate within 30 days with why don't we say King Pfeiffer or a mutually agreed upon mediator? But and then if you guys want to, if you'd rather do Shapiro, that's fine too. But if you can't reach an agreement for some reason, then you're going with Pfeiffer.
Thank you, Your Honor.
Do we have
right.
do we have a reset date for the?
Sure. Y'all prefer in person or remote?
Remote.
Yeah, I was gonna say they're from Harris County, so probably remote.
Okay. You have both options here. Let's see. So 30 days notice, it need to be at least 30 days from now. How about May 1st? Does that work?
Just making sure that's not the that works for me, Your Honor. Thank you.
I am checking. I actually have a trial set for that day.
Okay. April 8th. Sorry, May 8th.
I have another trial. Actually, that one I should be okay for May 8th.
We're gonna do May 1st at 2 o'clock.
I think she said May 8th worked better, Your Honor.
Sorry, May 8th at 2 o'clock.
That will be fine.
Sure.
All right, Rhonda, go ahead and reset this hearing for May 8th at 2 o'clock.
Okay.
Thank
All
you,
right,
Judge.
guys, have a great rest of your day.
Thank you too.
Ya le agarramos la onda al tinte para que no se te haga morado.
All right, I think we're still waiting for the other attorney, Ms. Marquez. Is that right?
Yes, I don't see him, Your Honor.
Okay, I think we're here, all here on the appeal of the associate judge order and the Lien case. Is that correct?
Yes, Your Honor.
All right, Tony, you ready?
Yes, Judge.
Let's go on the record on DC 216493, Lien versus Hernandez. Counsel, make your appearances.
On Marquez for Carla Alanis, who is the plaintiff in this case, Your Honor.
And John Helstowski on behalf of respondent.
Okay, you may proceed.
Your Honor, this is the fourth time that we've heard this case on this motion for new trial. And we may go to a fifth because I got served with a petition for equitable bill of review on this case. And we'll proceed any way that counsel wishes, but we'd like to know what how it affects us.
I think he's addressing that to you.
Opposing counsel?
Well, our argument's been the entire time, even after the order granting our motion for new trial, that whether we did it through the motion for new trial or a bill of review, it would have met the standard. So when we saw the request for this to be reheard, we just went ahead and said, why not just refile a bill of review as well? So that was filed. And we figure that while we have an order for new trial, that worst case, we would win under the bill of review, or that the court might see to it that it was consolidated, or I could dismiss it if we prevail today. But given the fact that there was never any sale documents and it was a default judgment, and this is the case where my client's attorney ended up being disbarred, and so there was it's not appropriate for me to say there was a default judgment. It's that there was an unanswered motion for summary judgment trial because he had lost his license and they didn't know of the notice, though he was properly served, the attorney, that this should be reset for a new trial. And so whether we get it by hook or crook, we feel that either the bill of review be granted, we have the new trial, or that the court would affirm the other order granting the new trial, and then we proceed forward with the trial. So
you want to go forward with this hearing?
Most definitely with this hearing and and just do the trial, so we cut out the middle. But if that doesn't work, then we can do the bill of review.
Okay, let's proceed.
Okay, Your Honor. The problem that I see in the associate order is that although the records of the court appear to show that an original answer was filed, it really wasn't. It was an answer to the TRO motion that was at the start of this case. So therefore, I believe the associate judge judged it on the basis of a post-answer default judgment and not a pre-answer lawsuit or a default judgment. In other words, the default judgment had no answer. When I went up and you called it for trial, I found out that there was no answer on file. So therefore, when we look at the case law, the cases are very clear that the answer to the critical question is, I got the suit papers, but then, in other words, if the complainant got the suit papers, which she admits she did because she claims she hired an attorney, the default judgment should be set aside only if the defendant proves the three elements of the Craddock case. That was never done in this case. And there was never any factual findings. I'm not asking for it to be in the judgment. I was asking for it to be part of the fact finding in the case. And so none of that was handled And because of that, we think that it did not apply correctly. The requirements for pre-answer or pre-answer default judgment. So
walk me through exactly the history here.
yes.
So Mr. Helstowski said that there had been a summary judgment that was not responded to. You're saying there was a default judgment that was not responded to,
Yes,
which is correct.
it was a default judgment on the date of trial, Your Honor, and you indicated that you would
Because they didn't show up to trial, or they didn't show up to the summary judgment.
They didn't show up for the judgment. We didn't file a summary judgment motion in this case.
They just didn't show up to trial, and so you took a default. Okay, that's a default then. All right.
Yes, Your Honor. So the courts are pretty clear that it's a critical question about whether there's suit papers, what she did with the suit papers, which she admits she gave to the attorney and the attorney mishandled or did not appear or whatever. And so none of those elements were addressed, and fact is we're entitled to have those addressed, and because they weren't addressed, the judgment is ineffective as a motion for new trial because it will not be recognized as a proper granting of a motion.
So let's look at our O'Connor's.
Well, and then since then, there was an order entered for a new trial. So this is like an appeal of sorts. So it's really his motion to rehear that's first up.
Yes, Your Honor. And the last time that we talked, you said you wanted it noted as an appeal, which I did. And so therefore, and you wanted, there was an ambiguous finding of a motion for new trial, granting the motion, and it did not show up in the judgment. And so therefore you had to come in and clear up the ambiguity. And so that's how there's a granting of a motion for new trial, which my recollection is not only was it not handled properly, it was also it wasn't even asked for, to be truthful with you. She just declared it. She granted the leave, and then she volunteered, in my judgment, that she would grant the new trial. And I would understand that if she had filed an answer. To this day, the defendant has failed to answer in this case. So we've been going through these post-judgment motions without even being a party to this case. So aside from the plenary arguments, which looking at the rules does not allow plenary jurisdiction.
So I'm confused. You said there was
Yeah.
never an answer filed. There was an answer on 6/21 of 2021.
And I'm looking at it right now, and that's the attorney that was disbarred that filed that answer as well.
But he didn't file a general denial. He filed a response to the parole application that we were filing at the time. If you look at it, I looked at it this weekend, Your Honor, it's still not a general. And so when you called it for trial and I showed up, see, files her response to the request for extraordinary relief. So the fact is, this is a pre-answer default, not a post-answer default.
You're assuming this is not an answer.
This is not an answer, Your Honor. And I brought that up to you at the time of the trial setting, and I realized you had a bunch of other cases at the time, but I indicated it was not an answer, and we went over this, and you indicated it wasn't an answer. It was not an answer. It's an answer to the TRO request, and he labels it this way, but he doesn't file a general denial. it's a response to request for extraordinary relief. It doesn't even say to the petition. So I think that the judge got sidetracked, the associate judge got sidetracked. And because it was mislabeled when it was filed in your court, Your Honor, she might have thought that there was a general denial on file. So,
I don't think that had anything to do with it whatsoever, Your Honor. I think that they filed the answer and the response, then they were in the case the entire time. And the first thing we filed was our motion for new trial on August 10th, 2022. The reason I didn't know if it was a default or MSJ off the top of my head is that we didn't get hired until after the order. And then it had to be verified. So you didn't rule on it. So then we had it reset, and these arguments were brought before, except for this one about you didn't file an answer. That I don't know that I recall hearing that the first hearing in front of the auxiliary judge. And so she ruled that there should be a new trial. Then we were before you on what's now the appeal. And I still think that the court looked at the motion we filed originally and granted it. So I don't understand what the grounds for appeal is. What does it matter if we filed an answer or not, whether or not there could be an appeal? But we did. There is a filing, and there's no special exception to it. So they've made an appearance in the case.
there doesn't need to be a special exception. The court cases say
Which
that,
ones? I don't see any case law here. I'm
Well,
looking at
I'm not-
ones. I don't see what court case.
I'm telling you the case law. Do you want to look it up?
Well, yeah.
Okay.
The only ones in your
Let me
position-
answer your question.
You only have in Ray Brookshire about the plenary power.
I don't have to. Here's the case, 573 Southwest 3rd, 341 Roman. The answer to the critical question is, I got the suit papers, but then, in quotes, the default judgment should be set aside only if the defendant proves the three familiar Craddock elements. Your Honor, I've always said that the Craddock elements have to be addressed. He has never addressed the Craddock elements. He doesn't like it because he doesn't like the elements. And so therefore, that's why he's trying to blackmail me by filing motions for review and wants it the other way around.
Well, your clients are in the house and they're not paying rent or the mortgage.
For whatever reason.
So it's not going to settle.
Whatever
like this,
reason
right?
your side plainly before you were there, but certainly on the advice of prior counsel, terminated her right to file to pay the monthly mortgage payments. So what does that have to do with anything? What we're here for is the three.
Where's the thing in your
Let me
motion
finish.
about the Craddock? I'm happy to
Okay.
respond. I just don't see it in here.
I've said it from the very beginning, from the very first response, it said you
I'm
had.
looking at the one for today, though, on the appeal. I don't.
Well, we're
see it.
looking at today that says
Yeah.
you have to address the Craddock elements. You did not.
Which are,
have a
and where is it
response.
in your?
Let me finish.
Guys, I'm sorry. For the record, you guys need to, you're talking over each other. I can't get both of you. Sorry.
Yes, Your Honor, he keeps interrupting me. The three familiar Craddock elements must be addressed. You and I know she did not address them. That's all that matters right now. And I've always said Craddock, and my appeal said Craddock. So
I don't see it. I'm reading
what
your
did
appeal.
you not see?
Can-
You
Wait,
didn't
wait,
answer
wait,
my-
wait. So okay, this is confusing. All right. In your motion for new trial, when was that initially filed?
Yes, Your Honor. The first one that I see is the filing on August 10th, 2022. And that one's the one that would be missing the verification sheet. That's the first filing.
And do you address the Craddock elements here?
Yes, so under arguments and authorities, we walk through our belief, which is that and we're referencing Collins and the Flores versus Haberman file, right? And in that the motion challenges the pleadings supporting the default judgment. The trial court should examine the pleadings to determine whether or not it was demonstrated properly. And one of the things that we're arguing is that The trial court must not decide the merits of party claims, but must confine itself to the evidence that's in front of the judge at the time. And here, because it was a default judgment, and that there wasn't, and this is a real issue, there's a statute of frauds. There's no contract with the parties he's representing that they own it. So there's no proof that they were buying it, given there's a lease agreement. And so in any event, that's in the first one. And then the second one that we did, which was more full because it was filed on 8/29 and it had the verification attached. Oh, sorry, I apologize. That's the response. Let me go back.
Hey, no.
Yeah, that was Mr. Marquez's response.
Marquez.
Thank you, Mr. Marquez. I apologize for mispronouncing your last name. There's a supplement.
So when is the second?
Made a motion for a lead, and then
Here it is. Okay, there's a motion.
there it is. On 1/27/2023, there's another motion.
There's another motion called when exactly? 127.
127.
No.
And it's titled, oh, it looks like it
I don't see it.
even starts with our existing motion. So I don't know that we drafted anything else there.
Motion for leave, I see, is filed on 11/22/2022.
I think that we really just added the verification on the, yeah, I see the 11/22/2022, and then
And then the end of October is what I recall, the motion for a new trial that was denied.
I don't know that there's no order granted at all on the denial. So the denial wasn't signed because we had to add the verification. And then that's the one that we had in front of the auxiliary judge. We argued Collins on paragraph 25 of that.
I guess my question is there authority that says under for a motion for new trial post answer? I'm going to assume there's an answer here. Post answer, does it require you to address the Craddock factors? That's kind of what I'm trying to figure out.
No, and it wasn't brought up in the responses. I don't see where that was, though I'm happy to find it.
Well, they're way more lenient if you filed an answer. That I'll admit, but I still think you have to. It certainly it comes to the point where it would be error to not grant it if they didn't show it. But since they didn't show it and they didn't plead it and they didn't answer my request for Craddock, I just think it's wrong to have given a judgment that was not even requested, to be truthful with you.
Why don't you argue Craddock then?
We were there on
satisfied.
the lead motion, Your Honor.
Why don't you argue Craddock then and see if it was satisfied, Mr. Marquez?
We can do it.
Go for it. Start.
Mr. Heldowski, you're not the judge here, so don't do that again.
Here's the point. I'll tell you what I think he's trying to say the three things are, and it's that there's three reasons. It says to give the trial court a chance to correct what the appellate will claim on appeal as reversible error, to preserve the error for appeal, and to extend the appellate deadlines. Right?
That is not. And thank you.
Oh, really? So
for talking for me. The question is, Your Honor, the three Craddock elements are the default was neither intentional nor conscious indifference. that they show a meritorious defense, and 3, that a new trial would cause neither delay nor undue prejudice. So none of that is addressed. And it was never responded to.
Right, response?
Sure. It's not argued in his pleading, so I don't believe the court should consider his argument. That's my main response, because it's really not in any of his answers. I still can't find it even referenced, but I can respond. So the let's start backwards, I guess. It wouldn't unduly prejudice your party because they're not paying anything to live and they have occupancy of the property. There was no intent not to respond or appear at the trial, but in our motion, you see that the court case that resulted in his disbarment was proximate to the exact same time as the trial, and he had been non-responsive to them the entire time. And that's attached as an exhibit. It's exhibit A to our, no, I apologize, exhibit, I think it's in the default judgment of disbarment for the District 7 Grievance Committee, State Bar of Texas. And I think that the date on that, I want to go to it and get it right. October 25th, 2022 is when the court signed the order on the disbarment, and the date of this trial was on it's in our first motion. It was right at the same time. And so they didn't find out that he had lost his license until after they finally got the default judgment, which was sent to their law. That's the other thing. If they didn't file an answer, then why weren't you sending any notice to them directly? You know, everything was sent to the law office.
Are you?
So that's how they didn't have any intent. This wasn't intentional, right? So, and that's, I think everybody was relying on the attorney, actually relying on them for noticing.
Well,
so they didn't get it.
I think we're in a hearing where we're not speculating here about what they thought or what they intended. Secondly, we contest the first issue about conscious indifference. This case started from the defendant filing an eviction action against my client. That eviction action ended up in an appeal with the county court with Judge Montgomery.
All right, well, we're getting way far afield. So let's just kind of, I want to go through this systematically because I'm letting you guys kind of jump around a little bit here. So first off is the issue is there an answer? And if you look up chapter 7A, section 3.8 of the O'Connor's, it talks about, or 3.6 of O'Connor's, it talks about what happens if you have a defective answer. And I think one of y'all said if the answer is defective, your remedy is to file a special exception. And they go through what constitutes an answer. And they found that filings, a letter from a pro se defendant where he confirmed he received the citation, provided his current address, that was sufficient. A motion to dismiss from a pro se defendant that contains the proper style of the case is sufficient. A plea and abatement, letter to the court from the secretary treasurer of a corporation is sufficient. An answer not signed by either party or an attorney is sufficient. I mean, it is a very low burden on what constitutes an answer. Now, if you filed a special exception, I would clearly grant it because I think that there's problems with the answer, but the remedy is not default. And so that's the first issue. So I just wanted to kind of get that out of the way. So this is a post-answer default. Post-answer default, I can't find anything that says that requires you, because if you think about it, the purpose of Craddock is to see if the failure to answer was deliberate, not the failure to appear is deliberate. And so unless you have case law to the contrary.
Okay, so they obviously filed, they obviously hired the attorney. The attorney filed a response to the TRO motion. So therefore, and never filed something indicating that he was no longer in charge of this case. So I'm looking up my review too, and I've seen cases that say that just filing a response to TRO is not an answer.
Okay, I don't see that what I've seen. So if you want to brief that issue, you can, but that's not what I'm seeing here.
Sure. Okay. I think I know. Okay, can you repeat your request, Your Honor?
Just if you have case law that says the responding to a TRO is not sufficient, now is the answer defective? Yes, but it is still an answer. That's my point. So in the remedy is a special exception, not default. Unless you found something that would be the first time in 17 years that O'Connor's would be wrong. But let me
keep looking. The bar is low to consider an answer, a general denial.
Okay, attacking default judgment.
Okay.
This is what I would recommend. It's not a final ruling, but what I would recommend, what I usually do in these situations, where it's a regular default, not this type of default, is I would, because I do understand, Mr. Marquez, that you showed up to trial and the other side didn't. I would typically encourage the parties to have the defendant pay the attorney's fees associated with obtaining the default judgment. I think that's more of that's definitely something that's allowed under Craddock. I think that's kind of what's fair here. Do you want to talk to your client about that? Or both of you talk to your clients about that?
We'd be willing to pay $1,000 for remedying the breach of not appearing.
Do you want to, Mr. Marquez, do you want to, your client is here. Do you want me to put you into a breakout room so you can talk to her?
Yeah, Your Honor, I think I did a statement for her. And let me look at the statement.
And that's probably about the most we'd be willing to pay because we had to do it 3 times. I asked and called opposing counsel about this when I discovered what happened. And the problem is it's all or nothing.
Mr. Hilhowsky, why don't you let him respond? Do you want to talk to your client or not, Mr. Marquez?
Your Honor, since filing the filing of the motion for new trial, I've submitted an invoice to the client of $6,336 for work from the first general denial from August of last year.
That's not what would be covered.
Okay, are you saying the appearance?
The amount that you incurred obtaining the default judgment?
I billed her $5,000, Your Honor.
Okay, well, I'm going to put you. Do you want me to put the 3 of you in a room to talk, or just the 2 of you?
I'll talk to my client.
Okay.
Are we going to get to the preliminary argument, Your Honor?
Why don't we deal with this first?
Okay. You know, I don't think it'll help for me to talk to the client. What is it you need from me, Your Honor? You want what the amount of time and the effort that it took to get Remember that you had me do
Let me
this?
just make a recommendation here. Let me make a recommendation. You guys can both talk about it. I think that your client should accept 2,500. You got, Mr. Heltoski, I think you should offer 2,500. It's not an order. You guys talk to your clients and let me know if that works.
Yes, sir.
We'll do 3,000.
Sure. Then all I'd like is a year's worth of rent payments because they've been squatting on the property. So we're paying the mortgage. Yeah,
Okay.
I'll happily ask for 25 because I haven't asked. I didn't go up that high ever. So I need to get authority.
Why don't you guys, I tried to put you into a breakout room, Mr. Marquez, but do you want to talk to your clients at this point? And
I can call her on the cell phone, Your Honor. I don't.
okay, I will mute you then. I'm going to mute both of you and I'm going to take care of my next hearing. You guys call your clients. Are both sides here on the uphold design versus Drew Baird case?
Yes, sir.
Yes, Your Honor.
All right. Tony, you ready?
Yes, yes.
I warned you about this afternoon. Okay, we'll go on the record at DC 224848 uphold design versus Drew Baird. Counsel, make your appearances.
David Welch on behalf of the movement and defendant Drew Baird.
James Bell for the plaintiff, Your Honor.
All right, let's proceed.
Thank you, Judge. We're here on a summary judgment, very simple issue, and got a unique spin to it that we need to figure out, but very simple issue to start with. I took the deposition of the plaintiff corporate representative, Mr. Juan Gomez, and in his deposition, he testified that the plaintiff has never done business, never done any work, never invoiced anybody, and never been owed any money. Receiving that testimony, we terminated the deposition. As plaintiff said in his response, we were going to explore some settlement. That never panned out. I filed summary judgment. They brought a breach of contract case and a quantum merit case, Judge. With the testimony from the corporate rep, they've never been owed money. There's no damages. They've never done work. They're actually a non-existent entity, even in Texas, but we haven't gotten to that point of moving on those issues. The unique part that you're going to see is I filed a reply on the 22nd, and I'm not sure if you've seen that, Judge.
I have.
But the plaintiff filed basically a fraud on the court, fake errata sheet, and that's never filed with the court reporter. It doesn't change the testimony. I've never seen it happen before. Mr. Shaw has been lawyer longer than I've been alive, has never seen anything like this before.
So I saw that there was an errata, so the errata wasn't timely filed. Is that right?
The errata was never sent to the court reporter, period. I was the one that showed it to the court reporter on the day we received the summary judgment response. And that's attached. The court reporter actually did a declaration, Judge. That's attached in my reply. That's Exhibit A to my reply. That's Miss Melody Monk. She never received the errata. The true certificate of the deposition was filed with the court by the court reporter, and that says there was never an errata to the deposition. That's also attached, and that's in the court's records. So I'm not sure what happened, where that came from, but that's not proper evidence. Even if the court's willing to ignore the
So
false errata sheet.
So what rule governs erratas? What rule number is that?
I just closed up my reply. Let me get that for you, Judge. I have it. It's under TRCP 203, Judge.
Okay.
That's what deals with depositions in general. So you had a certain amount of days, but it was never sent to her. It never changed the testimony. Now, the changes that were even attempted to be made are improper changes. They're trying to say that, I guess, the guy was confused on something. To make that kind of change in Texas, there needs to be an explanation and a reason why. These are simple questions, Judge. If you'll read the deposition itself, I attached in whole. because it's not very
I want to
long.
deal with the errata issue first. So I'm looking at Rule 203. What subsection of 203 are we talking about? Okay, 203.1B.
Let me make sure that's right, Judge.
Okay, so it says here, if the witness under 203.1B, if the witness does not return the transcript to the deposition officer within 20 days of the date the transcript was provided to the witness or the witness's attorney, the witness may be deemed to have waived the right to make changes.
Correct.
Okay, that I'm just pointing out what the rule is. So, all right, go ahead. So how do you respond?
Yeah.
How do you respond to that, Mr. Bell?
Yes, sir. If I may, Judge, a couple things.
Deal with the errata.
Okay. The deposition was finalized by the court reporter on March 15th. So what's that, 8 days ago?
Is that right? I don't know.
Yeah, 8 days. I mean, today's the 23rd, right? Or the 24th? Let me look at my file. It's the 27th. I apologize. So 12 days ago is the deposition was taken on February 13th. He filed a traditional and a no evidence. Got the transcript back. It was finalized. Here you go, Judge, by the court reporter. You can see that it says March 15th, 2023. So 12 days ago.
Judge, that's not the court reporter. That's not the court reporter he just showed you. That's a notary on the changes. The court reporter certificate was filed by the court on the day we filed our reply, or I think the night before we filed our reply. And the certificate says the transcript was provided to the plaintiff on February 23rd, and it was due back to the court reporter on March 15, 2023. The document he just showed you is the notary sheet that's not even filled out correctly for the errata changes.
Okay, so when was the deposition provided to my client? He's got 30 days to read and sign.
20 days.
Not true.
20 days to read and sign.
So what day was it? I don't know. What day was it provided, Mr. Welch?
February 23rd, Judge. That's all part of the reporter's certificate. If you're looking at the response, I don't have the date page, but it's page 42 of the PDF on the response is the reporter's certificate. And I can find you the actual one that was filed with the court. Let me give that to you, Judge. It's on page 33 of my reply overall, if you're looking at that document.
I'm sorry, what was the date that the deposition was provided to the client?
The court reporter provided the deposition, Judge, to the plaintiff on February 23rd. I think another important part to remember when we do this exercise, Judge, is to today, the plaintiff has never sent the certification to the court reporter. The rule clearly says.
Hey, Judge, hold on one second. He keeps talking about evidence that's not in your summary judgment record. He talked about something from Melody Monk, who's a court reporter, in a reply. That's not part of the court's summary judgment record. Court can't consider it. He keeps talking about evidence that's not in the court's record.
That's not true, Judge. That's in the record, and it's a response to their evidence. It's Exhibit A to my reply, which is a motion to strike and a response to their fraudulent errata sheet. And
Judge, Your Honor, what rule is there to suggest that if you attach an affidavit to a reply to a response to summary judgment, that makes it part of the summary judgment record? The rule is any and all evidence, unless it's done with a motion for leave, has to be on file at least 21 days before the hearing. Judge, I'm talking about water.
Okay. So
you don't get the fraudulently.
Wait. So we're jumping around here a little bit. So you raised for the first time, as I understand it, this issue of the errata in your response. Mr. Welch, I think he's correct that if you wanted to include an affidavit from your court reporter, that you would have needed to file a motion for leave to include that in the record for evidence. Now, argument I usually allow, but evidence you would need to file a motion for leave. And so I understand why you didn't do that in the initial filing, because you didn't know he was going to submit the errata. So I do think we might be premature here. I think what might make sense, I'm just kind of thinking out loud here, is maybe you would file a motion to strike the errata if it was untimely. I don't know if it's untimely or not. I can't tell from based on what you guys are saying. It sounds like it's untimely, but I don't know that for sure. And then you would need to file a motion for leave. I would need to give him additional time to respond to that, but I do think this is kind of premature because of this issue involving the errata. If you think that's important, Mr. Welch.
And if I may,
think it's very important because I think it's
Well,
sanctionable.
Mr. Bell, let Mr. Welch respond.
I think it is very important because I think it's sanctionable and it's a fraud on the court. But do I think that that's needed to necessarily beat the summary judgment? No. And here's really why. I'm happy to do whatever the court wants, but if the court looks at their response, they attach a sham affidavit of Juan Gomez. And in that, he does not explain why the testimony that he gave in the deposition needs to be changed or different. So one, that's a sham affidavit. But number two, assume the court wants to allow all their evidence in, and that's what the court wants to rule on and allow. Look at the invoices, Judge. They attach 4 invoices, B, C, D, and E. Look at who those are for. Defendant's name does not appear on a single invoice. There's no bit of evidence that supports these services were provided or these invoices went to defendant. Exhibit B, 4, Teresa Slattery. C, Bill 2, Teresa Slattery. D, Bill 2, Teresa Slattery. E, Bill 2, Teresa Slattery. So even if we ignore the grievous errata and the misleading the court, they haven't presented any evidence that supports a claim against defendant by this plaintiff.
Okay, response to that, Mr. Bell.
Yes, Judge.
So what evidence is, because this is pretty unusual, Mr. Bell. What evidence is there that, because based on your client's testimony, he said pretty clearly, I didn't do any services for Mr. Baird. And then is there an invoice where Mr. Baird was invoiced?
Judge, if I may, I mean, I'm happy to answer the court's questions.
So go ahead and do that. Go ahead and answer my question.
Yeah, there's an affidavit in the summary judgment record saying that he provided the services, over $100,000 worth of services to the plaintiff.
But where's the invoices for it? And I'm not saying you're wrong. I just want to see them.
You want to see the declaration of the client that says
No. I want to see the actual invoices where he billed Mr. Baird.
Okay.
If there is any.
It was sent to Teresa Slattery, Judge. He was the subcontractor on this deal. And if you read his affidavit, I understand he's shaking his head.
She was the homeowner, Judge.
That's right. The deal wasn't with the homeowner, as is the case with many contractors. He provided all the invoices, and the deal that was cut was with the general contractor. And that's in the affidavit, that's in the summary judgment record. If you look at page, let me pull it up. All right.
So let me make sure I understand the relationship of all these people. So Uphold Design was a subcontractor for Teresa Slattery?
No.
Yes.
And then Baird was the homeowner?
No, Slattery was a homeowner. Drew Baird was a contractor. Uphold was a separate contractor.
Okay.
That's why it's billed directly to the homeowner. Well, let me clarify one thing. The LLC was never anything because the LLC never functioned. Whether or not Juan Gomez did some work for somebody under some capacity, I don't know. But I know for certain the LLC never did anything. There's no proof that this plaintiff did anything, period.
Judge, if you look at the declaration of Juan Gomez,
Right.
okay, paragraph 6. On December 7th, 2021, Baird and myself met at the property with the homeowners, Terry and Teresa Slattery. We did a walk through the property to review and discuss the work to be done. There were no architectural drawings provided by Baird, which is customary in the industry. This made the job of Uphold Designs and other subcontractors much more difficult. On December 9th, the estimate was provided to Baird. Baird agreed to the amount and told me that Uphold Designs would begin services after the plumbing, electrical, walls, and flooring were complete. A true and correct copy of this estimate is attached as Exhibit B to this response. On the 12th, Baird paid $40,000 towards the balance. Baird paid $40,000 towards the balance of Uphold Design services, and Uphold Designs sent out an invoice for its work to be performed. A true and correct copy of that invoice is attached as Exhibit C. On January 17th,
So, Mr. Bell, though, these invoices are to Teresa Slattery. They're not to Drew.
They were sent to Mr. Baird pursuant to the affidavit. They may have Slattery's name on it, but they were sent to Baird. I guess I don't understand what he's trying to do is he's not denying that my client, I mean, is what he's saying my client didn't perform services over $100,000 worth of services on behalf of his client? I don't understand. This guy.
I think what he's saying is that they were both contractors for Slattery. Why are you suing me? Why are you suing Baird? Is that what you're saying, Mr. Welch?
Yeah, Judge. One, I'm saying I don't know who this LLC is, but two, if these bills are for Teresa Slattery, where does my client fit in? Where's the proof and the explanation of that? Because I just see invoices to Teresa Slattery.
In terms of
it's not even explained in the affidavit. Hey, these bills say Teresa Slattery, but here's why. None of that's in there. I don't know what's going on, but it's not summary judgment proof.
Okay. The affidavit says Uphold Designs fully completed all the work invoiced to Baird. Even though it's got Slattery's name on it, it was sent to Baird on April 27, 2022. Uphold Designs completed all the services contemplated in the agreement between Uphold Designs and Baird. Baird failed to comply with Uphold Designs in terms of paying the outstanding amounts under the contract. Now, Judge, if you go back to the deposition on February 13th that Mr. Van Shaw's associate did, he shut down the depot and said, made in a Rule 11 agreement that said, instead of taking the defendant's deposition the following day, the folks were going to do some settlement negotiations. We haven't had a chance to take the deposition of the defendant. Okay. And instead he filed this motion, which, oh, by the way, is a traditional, but also a no evidence motion for summary judgment. Now, the no evidence burden is a scintilla of evidence. The declaration that's in the court's record is enough to get past both the traditional motion and a no evidence motion. And we have, Judge, discovery hasn't been complete. The only time you're allowed to file a no evidence motion is when discovery is complete. It hadn't been completed. If you just look, Judge, in terms of our record, attached as exhibit, let me look here, pull it for you. If you look what Mr. Welch said, he said, let's look here on the list. He said that they would take my client or take his client's deposition at a later date, is what he said at that deposition, a month and a half ago, Your Honor. So the defendant's deposition hasn't even been taken in this case.
I get that. So I'm trying to understand his answer. It says Uphold Design LLC has never done business fair. That's correct. He's never done any work fair, never invoiced anyone. So was he trying to say that he did the work himself and it shouldn't, the LLC isn't?
No, what he tries to say is the client, Mr. Welch, was confusing him regarding the distinction of being registered to do business in Texas versus actually doing business in Texas. And so we submitted the errata sheet, which was filed timely. Whether or not that's in terms of what's in the summary judgment record, it was filed timely, sent to the court reporter. It says this confusion had been corrected through the plaintiff's errata sheet. That's in the summary judgment record. It wasn't objected to by the other side. And the defendant in this case filed the motion before waiting for the deposition errata sheet to be completed. So clearly this motion is premature. And even assuming arguendo it wasn't, you've got a declaration which overcomes any and all hurdles with respect to getting past both a traditional.
Why isn't Slattery a party in this case? That's what I'm not clear about.
Are you asking Welch or me?
Either. No, well, I mean, it seems to be all the invoices are to Slattery.
The deal was cut with Baird, Judge. I mean, every time a subcontractor, the subcontractor may put the name of the owner of the property, but the deal is cut with the GC. Baird is who the deal was cut with. Obviously, it would be a lot easier to sue the homeowner and file an M&M lien on their property. But the client did it the right way. The client was solicited by Baird, and the client did the work for Baird at Baird's instruction and at Baird's approval. And Baird's the one, Judge, this lawyer sitting right here, he's not going to look at you in the eye right now and say, Baird never paid Uphold Designs. Just ask him right now. Ask him point blank. Did your client pay Uphold Designs? And if the answer is yes, my client did pay Uphold Designs, then you're really going to know what's going on here. And you're going to know who's perpetuating a fraud on the court. Ask him who paid my client. Just ask him.
Who paid your client? His client?
I don't know, but here's what I want to know from them.
No. That was the dodge.
Where is it in the Judge? Where's it in the summary judgment evidence? Where's the proof of payment?
Guys, enough. I appreciate the argument. So I think at this point, I do agree with Mr. Bell that this is premature, that we need to go ahead and let the discovery go forward. If you want to file a motion to strike the errata, that could be significant, and set a motion to strike the sham affidavit, if it is a sham affidavit. But I do think it's premature, and I do think there should be an opportunity to do more discovery in this case, because it doesn't, if Mr. Welch, you don't know whether or not your client had been paying the defendant, that's a pretty significant issue in the case. So at this point, I can either let you withdraw it for now, or I'm going to deny it without prejudice to you filing it.
Can I just make two notes, and then I understand the court's ruling. I just want to make two notes for it. One, there's no motion to continue this summary judgment hearing. This is all complete fugazi to come in here and then say discovery is not closed. If you read the deposition, Judge, the reason the depot was shut down the way it was because they know that they were hosed. The answers to these questions are clear, but if we need to button this up tighter to prove that further, Judge, I'm happy to do it, and we can just reset this for a later date. But that's why it happened. Mr. Bell came in here, and the reason he doesn't know what's going on is because he's not done a thing on this case. It's been his associate, Mr. Nash. We've been in the court a couple times. They've changed the plaintiff 2 or 3 times. They've changed the defendant 2 or 3 times. It's a really weird deal going on here, Judge, but I understand if we need to cross some more T's and dot some I's, because we're going to be coming with sanctions motions at the end of this thing. So I'm fine with that, Judge, but I understand.
Sounds good. You guys have a great rest of your day, and we'll see you on the next one. All right.
Judge, I don't want to make a note, and I don't need to do anything.
Guys. Okay.
Can I ask one question, Judge? I just, can you make sure that can you ask or order that I get the deposition within 2 weeks of today's date? So we don't have to file a motion to compel?
We'll deal with the Rule 11, Judge. We'll handle it because I get his depo first. That's what the Rule 11 says. But we'll deal with that. And thank you, Judge.
Let's get the discovery done. Let's get the issue on the errata sheet because that hasn't been briefed on whether or not that was proper or not, and deal with the issue of the sham affidavit. But I do think there needs to be more discovery, more clarity here. So, all right, guys, thank you so much. You have a great rest of your day. Mr. Marquez, Mr. Helstowski, are you guys here? Where's Mr. Heltowski? Did he leave? No, there it is. All right. Did you guys work it out or where did he go? Mr. Helstowski, are you there? Have you talked to Mr. Marquez? I can't hear you, Mr. Marquez. You're muted. Mr. Marquez, have you guys talked yet?
I haven't talked to him, but
Turn it down.
we're
I
thinking
think the court called us back, or we might be in a.
Yeah,
it just happened.
we called you back. What? So do you guys get a chance to talk? Have you guys worked it out?
I had to turn up the volume. I missed everything. I apologize, Your Honor.
Have you had a chance to talk? Did you work everything out?
Yes, I've got my client still on the phone, actually. I think that we would begrudgingly would pay the $2,500 while they hadn't received over $20,000 in rents these past 2 years while this has been going. It's the most efficient way, and they're paying the mortgage every month. So we will capitulate if it's acceptable to Marquez's client.
Mr. Marquez, I encourage you to take the win here.
yes, Your Honor.
All right, go ahead and prepare an order for me on the motion for new trial. It'll be conditioned on the payment of the $2,500. How much time will it take for your client to pay the $2,500?
Ask her.
Elsa, hello, Arcelia.
Can I have
Me están preguntando cuánto
2 to 3
tiempo
weeks?
va a durar para que ustedes puedan.
14 days.
Yes, sir. And then
So include that in the order, Mr. Marquez or Mr. Heltowski.
yeah.
And that's it for today. You guys have a great rest of your day, okay?
What should we look out for next? Just a reset of the trial date? Is that how this would normally go, Judge
Yeah, so
Hoskins?
we need to, you got, your client's going to have to pay the money first. It's conditioned on the payment. So once it's paid, then you need to reach out to Rhonda and then we'll set the trial setting. You got to get that done right away.
Yes, sir. And then, Juan, your clients aren't living in that property right now, right?
Yes, they are.
Okay. What I was wondering is there an opportunity? I don't do many of these, probably clearly, right? Given the circumstance. Is there an opportunity to do the deposition and mediation prior to the trial setting, or is it customary?
Yeah, we
go right into the trial.
We definitely need to do depositions.
Great. Juan, sir, may I call you afterwards? And
Yeah,
then
by all means.
whatever we agree on that then.
Okay. And what about the plenary, the jurisdiction, Your Honor? 200 days.
Oh, it's moot, right?
It's moot. You guys reached a deal.
Okay. All right.
All right, get me an order, agreed order of for new trial with the $2,500 payment conditioned on it, and we'll set it for trial and get this thing moving.
Yes, sir.
Counsel will provide the order, or do you want me to, Your Honor?
Why don't you do it, Mr. Helstowski, and then you share it with Mr. Marquez. Make sure that this was agreed order was heard.
I'll make sure everybody signs it before it hits your desk, Your Honor.
That's even better. All right,
Yes,
thank you so much, guys. You have a great
Thank
rest
you,
of your day.
Yes, sir.
Okay, Mr. Rowland, what are you here for?
Afternoon, Your Honor. The Childers motion to compel depositions.
Okay, I think that's set at 3:30, correct?
Yes, Your Honor.
All right, you're opposing counsel here.
Not that I see, but they filed an answer today, so I suspect one of them will be.
All right. Childers, yeah, okay. Mr. Grennan, are you there?
Yes, Your Honor.
Are you here for the motion to compel?
Yes, Your Honor. My camera for some reason is not turning on.
Okay.
I'm sorry. I keep on trying to get.
No complaint from me, Your Honor. He's a better looking guy than I am, so I don't mind him not being on camera.
As long as you're, I noticed that there's a motion to withdraw on file. Is that involving this case? I mean, is that involving this hearing at all?
No, Your Honor, not that I'm aware of.
No.
Okay. There's not a question that both of you guys are the right hand. And then the plaintiff's lawyer, is he going to show up for this?
That's Mr. Grennan.
Oh, it is. Okay.
Yes, Your Honor.
I believe the withdrawal was one of the co-defendants was represented by an attorney who was not present at a lot of, I mean, I guess any of the case events so far, and then he withdrew. And I believe that order was signed, so I think he's officially out.
All right. So what's the issue here, guys? I guess let's go ahead and go on the record. Tony, let's go on the record on cause number DC 216913, Childers versus Allied Waste Systems. Counsel, make your appearances.
John Grennan on behalf of the plaintiffs.
Aaron Rowland, attorney on behalf of the Allied defendants, and Leonard Walker, or I guess the estate of Leonard Walker.
Okay.
May I proceed, Your Honor?
You may.
I think we can make it pretty short. Mr. Grennan's office sent some dates this morning. I believe it was 5 dates for May, so that helps. I would like to point out a couple of quick things, though, is it's a number of depositions by my count, roughly 17 that we've asked for, not unnecessary depositions. There may be 2 or 3 that we can avoid depending on how some of the other investigating officers, how some of their testimony goes. But I mean, at the very least, we're looking at 15, and that does not include my own experts that we've retained and that I assume plaintiff's counsel wants to depose. So I don't think 5 dates is going to be enough total. I think it's probably going to take more than that. But we do have some dates now, so that's fine. I just would ask that the court enter an order, and we can draft one or send it to plaintiff's counsel, that just stating that these depositions, not only will there be dates passed around, but they'll be agreed sometime in the next 60 days, or if that's too tight, we can do 90 days, or whatever the court wants. But I would also point out that we're set for trial. Yes, Your Honor. June 6th. So we are in a very tight spot with the dates provided to me this morning were all May dates. So all of them but one are within 30 days of the setting. So, and they're just, some of these are basic fact witnesses that either saw it or were there. or investigated as officers. So frankly, I think the dates are probably too tight for our current trial setting. So we'll be filing a motion to compel, but I haven't talked to plaintiff's counsel about that yet. So
Motion to compel or continuance?
sorry, I apologize. A motion for continuance as well.
Okay. Mr. Grinnan?
Yeah, we haven't talked about that yet. I'm obviously open to talk to Mr. Rowland about that. I think though that Mr. Rowland's correct, that we are in the process of getting all these depositions worked out. I don't know if like all of the depositions that they've requested are actually going to be necessary, because there are a handful of people on there that were friends, I think, of some of the deceased's that obviously were not eyewitnesses. I think that, well, long story short, I think that he is overestimating that he needs all 15 of these depositions. I don't think he'll take all 15. I know that we don't need to depose any of their experts, and we'll reserve that for trial. But long story short is we're giving them dates for them to take the depositions they want for trial.
Okay. Well, what do you want to do at this point then?
I would just like an order, Your Honor. Defense would request that. Mr. Grin and them have been great. I think everybody's schedules have just been busy, and sometimes I think things just get pushed longer than they should, and an order seems to help sometimes. So order for agreed dates for my office as well as his office to have agreements on dates for these depositions in the next 60 days, or 90 or whatever everyone wants to do.
What I would suggest you guys do is, why don't you two talk? I mean, just giving an order saying all depositions can take place within 60 days is pretty hard to enforce. And so I would suggest you two talk and then come up with an agreed order that says that following depositions are going to be taking place on these particular days, and order that to occur. I think doing it this way, just with a vague order saying all depositions take place, is just kind of asking for trouble. So give me an order generally, and if you guys want a continuance, case is a bit old. I would probably be willing to grant one, but we're trying mostly 2019 and 2020 cases, but we have tried the occasional 21. So you guys are kind of getting into where on the hot seat, so to speak. So if you want a continuance, I would suggest you guys talk about it and see what you can work out. How much time would it take you to work all this out?
On the depositions, if we could get on a phone call right after this, John's been great to work with. So I assume we could probably work out dates or get it all worked out just in a handful of days.
So why
Aaron,
don't
I'm sorry, Your Honor. I totally did not mean to interrupt you.
go ahead.
I was going to say, Aaron, I cannot get on a call right after this, but I promise you I can get on a call later today or this evening.
Okay.
That's
Yeah, I'll
it.
email you. Just check your email. We'll get on a call.
You have my cell phone, don't you?
I think so.
Okay.
Why don't you